Morning and welcome to the program. Our first guest of the morning, that of course is you, Angelo Fick. You know, when I read my script this morning, I said, gee whiz, we have two Ficks on the show this morning. It's Angelo and then also Advocate Fick at Outer. Uh, anyway, welcome. Nice talking with you. You are the Director of Research at ASRI, and we are looking at the issue around the Concord being wary of imposing new electoral systems in ruling the Electoral Act unconstitutional. Is this something to be concerned about given that the elections are around the corner, and how time consuming and complicated is this issue? Is it going to have a negative impact going forward regarding the elections?
Salaam alaikum to you and to your listeners. And I have no relation to Stephanie Fick, so you're not family stuck in your show. Um,
Okay.
I think it is an important moment in South Africa. I think we have moved beyond the settlement of 1994 in terms of our electoral politics. The Constitutional Court judgment in the New Nation issue, affirmed this, that we cannot simply have a situation where only parties can stand for election, where individuals should have the possibility, as they do in local government elections, to stand in national and provincial government elections. And that would deepen our democracy. It would, I think, allow for greater accountability. But how we move from the old system of proportional representation on party lists to incorporating individuals who stand on their own and wish to appeal to voters in their millions or thousands to vote for them, that's a complicated process that the court has acknowledged in the New Nation judgment and gave Parliament the task of having to formulate the laws that would allow for this. Since that 2020 judgment, we've seen almost 3 years, if not slightly more, pass. And Parliament's solution to this, that the President signed into law in April this year, was the system that we currently have. There are several challenges to it, and two of those challenges were directly opposed at the Constitutional Court, and that includes the signature requirement that a political party only, already registered would not require the new signatures, and before only required 1,000, and that all new political parties and all independent candidates would have to get 15% of the electoral roll in support of them, and that could be up to 15,000 votes in some places. For the second issue, it had to do with whether or not the formula worked out by Parliament for how many seats or how many votes an individual would have to get into the National Assembly or to get into a provincial legislature was felt to be unfair because it was almost, if not sometimes, more than double what a political party required. So a political party required 45,000 seats to get a candidate off their list into the National Assembly. That could go up to 54,000 depending on the voter turnout. And an individual would need almost double that, between 80 and 90,000. And this was felt to be unfair as a burden on individuals, because individuals, no matter how many votes they got, could only get an individual seat in the assembly, whereas actually what happens with political parties is they would get a seat for the number of votes they got, and then there is another 200 seats in Parliament that are apportioned according to the proportion of the national vote that a party got, which of course an individual wouldn't have. And so there were all sorts of concerns about equality before the law and equality of candidature on both matters that the court had to consider.
Okay, but then that also begs the question, with these individual candidates regarding their support base, the amount of work that needs to go into all of this in preparation of all of this, and just how fair the system would be to them. Given that if we have a whole host of independents coming on board, can you imagine the nightmare as far as that voters' roll would look like? So how does one navigate through all of this? Trying to weigh up the fairness of the situation. And also there are some candidates, hopefully, that are truly are truly there to represent the rights of the people and would make excellent parliamentarians and truly take our issues to Parliament and hopefully get results as well. So, wading through all of that, how do we see this playing out? The Constitutional Court is also suggesting that they are now being almost tasked to be doing the work of Parliament. Parliament should be or should have resolved all of these issues, I suppose, a while ago.
Absolutely. And Justice Tron actually pointed out that the separation of powers is such that the courts cannot make the laws. The courts can task the legislatures to make the laws, but they can't make the laws up themselves. And given the remedy that was sought, that actually the Constitutional Court should judge that there should be a 350-50 split, not a 200-200 split between directly elected and proportional represented candidates. Justice Tron and I think several of the other justices questioned whether this would not undo the separation of powers, which only allows the courts to judge on existing laws or to instruct government to improve existing laws or proposed laws, but cannot formulate laws themselves. This, of course, is a sacrosanct aspect of post-apartheid South Africa, and so it would not be, I think, a valid moment for the court to begin to make that law and to find a judgment in that way. The difficulty, of course, that the IEC faces is that, one, it needs to construct a ballot that millions of South Africans wishing to vote can make sense of. And already there was talk of 98 possibilities on one
Ooh.
page of the, ballot. And then, they may have to go to a second page if all 300 parties currently registered contest, and if more independents stand and have stood in the municipal elections, the ballots could become 4 to 5 pages long, and this could become difficult. Now, Parliament could have, of course, obviated all of this. It could have come up with a very different system. And this is where many of the litigants suggesting that the Constitutional Court judgment should come in their favour, argue that Parliament protected parties' privilege by going in this direction. They could have come up with a constituency-based system mixed with a proportional representation system. The country could have been divided into constituencies in which the ballots in different constituencies would have looked different, and so you wouldn't have had these 400 or 200 or even 100 names on a ballot. You would have had the individuals who stood in that particular constituency or ward, and your ballot would look more or less at the national and provincial elections the way it did or does in municipal elections. Now, the Home Affairs Department says that, well, what's going to happen is they need this interim arrangement for 2024, and then they will work on longer term electoral reform for future elections. And, the litigants argued that actually this is unacceptable, that the judgment in New Nation already tasked Parliament with coming up with this. And if this is going to be a longer process, the difficulty is voting people in 2024, they will then be in charge of rejigging the electoral system. And so I think South Africans have a right to be concerned. The IEC must come to the party, and the Constitutional Court has the difficulty, as it always does, of having to judge in citizens' interests, but at the same time uphold the separation of powers doctrine, as well as make sure that the law works itself out. And so next year's election is going to be difficult in a whole variety of ways. It'll include people who want to be on the ballot, and as you've pointed out, for very good reason and with great earnestness, wish to go and represent their communities or their constituencies in Parliament in a way that they feel and have felt that, parties do not, because you can be very loyal to a party, but absolutely uninterested in the citizens who voted for that party, as many judgments and issues over the last 10 years have shown. And there's nothing you and I as citizens can do to easily remove somebody from the National Assembly or a provincial legislature. Whereas a party can simply decide, no matter how well-meaning, ethical, upstanding, and focused on citizen interests a member of Parliament might be, if they don't toe the party line, they can be removed from the party and thereby lose their seat in Parliament. And Dr. Makosi Khoza is an example of how that has happened in the past. And so interesting
Angelo,
time. I think citizens have the right to be focused on and demand the best of both their politicians and the judiciary.
sorry for that interruption. I just wanted to say we need to go for an ad break, but the other issues we need to look at, and we need these questions answered. Obviously, what are the IEC saying about this drama playing out now? We spoke about independence truly wanting to serve the needs of the South African people, but you're also going to have a lot of Johnnies come lately who may look at this as an opportunity to make some big bucks. I don't know. I could be off the mark here. And also, does it suggest that if this issue is not resolved amicably, that there is a possibility, God forbid, there is a possibility that the elections will be delayed? And what would that impact look like on South Africa? So let's go for an ad break and come back and look into all of those issues.
winter warmth campaign. Sayyidina Umar al-Khattab radiallahu anhu would advise his companions, winter, which is an enemy, has come, so prepare for it with wool, leather socks and socks. Let us help the thousands of South Africans without adequate clothing or shelter to prepare for the harsh winter months by providing them with blankets for 150 Rand and winter warmth packs for 300 Rand. Spread warmth with African Muslims Agency. Call AMA on 011-834-8685 or donate online at africamuslimsagency.co.za. African Muslims Agency. Empowering, educating, inspiring.
Shimmer, sparkle, captivate. Nothing less than a masterpiece. Droplets of gold inspires precious design. Platinum bursts with intricate freshness, and every pure diamond becomes more than just a girl's best friend. Voda Gold Gem Jewelers, where timeless dreams become a reality. Come to us. We tailor-make designer gold, platinum, and diamond jewelry. Trade in or remodel your old gold. Clad yourself with classy name-branded watches. We offer insurance valuation and freezer card calculation. Visit us at 534 Ridge Road, Overport, or call 031 208 9142. Voda Gold Gem Jewelers, manufacturers of fine gold and diamond jewelry.
As the chilly winds sweep across our beautiful land, let us remember those in need. In South Africa, recent weather conditions have left many vulnerable individuals and families struggling to stay warm and nourished. With Ashraful Aid, you can donate a loaf of bread for 10 Rand, a blanket for 150 Rand, or soup for 100 people for just 230 Rand. Donate today at www.ashrafulaid.org. Winter warmth, it starts with you.
Discover the Africa of your dreams and surround yourself with her spectacular beauty. Relax beneath her serene sunsets and explore wildlife at its natural best. It's where the pride of Africa comes together. The Kwantu Private Game Reserve. Get to know the Big Five or cruise on an elephant safari game drive. Interact with lion and tiger cubs and enjoy world-class halal cuisine while we pamper you during your 5-star stay. Indulge in the true African experience. For reservations, call now on 042-203-1400 or visit kwantu.co.za. The Kwantu Private Game Reserve, the place of gathering.
The Turkey-Syria earthquake is among the deadliest earthquakes of the last century. Thousands have lost their lives, and large areas and cities and towns in southern Turkey and northern Syria have turned to rubble, leaving huge numbers of residents with very little or nothing at all. Al-Imdad Foundation's emergency relief team is on the ground providing life-saving aid. The people of Turkey and Syria desperately need your support. Donate online at alimdad.com or call 0861 786 243 for more information.
Listen to something fresh. Listen to Salam Media, your humanitarian broadcaster.
Bismillah ar-Rahman ar-Rahim. Welcome back. It is exactly 19 after 8 o'clock. My first guest this morning is Angelo Fick. He is a director of research at ASRI, and we are looking at the Election Amendment Act, which was contested in court regarding obviously the imposition of the new electoral system in the Electoral Act, as I've said, and that supposedly is unconstitutional. Let me say that all over again, because I think I made a bit of a hash of that. Concord is wary of imposing a new electoral system in ruling the Electoral Act unconstitutional. I gave you a few questions before the ad break, Angelo. I'm also wondering if they do either way, if this is passed or not, some form of mass voter education would have to be undertaken. Otherwise, the voters are going to be totally, totally confused. And I think we're going to have either a lot of spoiled papers or people being so confused that they are going to be voting for the wrong party or the wrong candidate. I have a huge fear about that situation.
Absolutely. And, voter education is going to be crucial. And for this, the IEC will need a lot of money, and various community organizations and civic organizations are going to have to get involved because this election is going to be so crucial. Projections were that the current governing party would not get an outright majority. And so it is important for voters to know that the election outcomes will be verifiable and that the election is therefore, valid. We've just seen the situation in a neighboring country, and we've seen situations elsewhere in the world where elections and their outcomes are questioned by opportunistic politicians. The IEC's response to the Constitutional Court, of course, is that, the difficulty of running elections is that it's only based on what it is that the legislation says, and therefore they can't design ballots until this particular matter is settled. I don't think the Constitutional Court will be particularly interested in extending the elections. We know from their judgment on the 2021 matter on the local government elections that they weren't interested in exceeding the constitutionally mandated time that lapses between elections. And so the elections had to happen in the middle of what was considered to be a massive, health crisis and health challenge. But we went ahead with those elections and they were successful. Before the outbreak, you asked about joke candidates or candidates that are only interested in it for the money. We've seen people try that before. We've seen people pay the amount of money, the deposit required, go through the campaign process and not get anywhere near even, 10,000 votes.
Sure.
There have been several parties like that, organizations. They include a movement that went under the banner of Purple Cow. I think they were the South African Capitalist Party.
Goodness.
We've seen the Soccer Party, we've seen the Dacha Party, and all of those parties were around, but the amount of effort that goes into this, as one of counsel argued before the justices, is such that it is in itself a deterrent. And so to put in that amount of money as a deposit.
Can I come in here, Angelo? Should there not be some sort of barriers or criteria in place to prevent these people, coming in, wasting a lot of time and money? And you kind of wonder what is the agenda and how cumbersome then it becomes for perhaps the IEC and other people that are so committed and interested in getting the elections being totally fair, and transparent. Surely some sort of criteria needs to be in place to just keep the jokers out, so to speak. And what's
So that,
in it for them up to this point in time?
Right. So there are criteria to prevent somebody from just going, I want to be on the ballot. You have to get a certain number of signatures, 1,000 people. You have to pay a non-refundable deposit. You only get the refund if, you get enough votes to get into parliament. So we know that those barriers have, shall we say, deterred many, many people who may wish to muddy the waters. But we also know that there are people in parliament who have gotten into parliament based on projects that the people who supported them then found was actually very different. And so the betrayal that people feel in supporting those kinds of organizations have been real. Now, this is not to say that they're joke candidates or that they are frivolous candidates. It's simply to say that how those organizations got into parliament resulted and comes on the process of many, many thousands of people disappointed. So Ahang SA, for example, had many, many thousands of volunteers very unhappy after the 2014 election because of the way in which they felt that Dr. Mampeli Rampele managed her relationship with the party and the DA. We've seen thousands of COPE voters migrate away from the Congress of the People in the wake of their internal battle. So this is not new, but we don't want to go into. There are two extreme examples of those kinds of candidates in the world. The one is the United Kingdom, which has a constituency-based system. And in that system, joke candidates are allowed and they function in a particular way to satirize the limited effect of the mainstream political agenda. And they can do so effectively because it's a constituency-based system. So you can run a candidate for something called the Monster Raving Loony Party in, let's say, a particular ward where the Conservative Party or the Labour Party will win, but there are thousands of people who don't want to vote for either of those two parties, so they can vote for you as a way of spoiling their ballot, but indicating that they're unhappy with the system. The other extreme is, of course, the Philippines, where to be a joke candidate is called a nuisance candidate. And this is any candidature that tries to satirize or bring into disrepute the electoral system. That's a criminal act. We don't want to do that. The whole point, I think, in the Constitutional Court justices yesterday and in previous judgments argued and kept pointing out of the post-apartheid electoral system is to provide for greater participation by people. If people wish to think of the political election system as a way of making money, we know that that is already happening at various levels. People join parties for reasons that have very little to do necessarily always with the party's agenda. And the African National Congress has spoken about this in public, about how they increasingly find through the 2000s and 2010s that people have joined the party for monetary reasons, to get access to resources or positions or election offices. And that's a crisis for the party. This, of course, happens in other spheres of life. The only way to stop that is to have, as you pointed out at the beginning of this particular question session, better voter education, that voters do the necessary homework and begin to uncouple candidates from the promises that they make. And that, I think, is going to be a major challenge for all of us in the next decade, which is, given what the literacy crisis is in South Africa, we desperately need to inform ourselves and inform one another. And the livelier the contestation, the better it is for democracy. We don't want to go in the direction of the United States, where there are two big parties, and like the United Kingdom, where they take turns governing, but they're actually much less interested in the citizens and much more beholden to the big businesses and multinational corporations that fund their billion-dollar campaigns. What we need in South Africa is greater participation by people, and the opportunity to change the Electoral Act to allow for that participation by individuals was missed, I think, largely by the parliamentary reforms that were introduced. And hopefully the parliamentary reforms promised by the legal representation for the Minister of Home Affairs will continue over the next 5 years, and we will move towards a system of greater accountability, where citizens have the ability to directly elect a representative in the National Assembly that represents their regional and very specific local interests, and have an accountability to them where they can recall that person, even specifically because that person is not doing what they require of them, and don't have to rely on a party to make that decision. I think we've outgrown the party representation list system, and we need to get ready for greater accountability to, one, wrestle our politics away from money, wrestle our politics away from corruption, and make councillors much more accountable to the people who elect them than they are at the moment, given that they're mostly accountable to the parties that put them on the list.
Huge task ahead of all of us. We ain't going to get it right overnight. Not at least in the next 5 or 10 years, but lots of hard work for you, I, and the layperson on the street. And if we don't educate ourselves and understand how our politics are playing out, then the country is in dire straits, is all I can say. And that, of course, is the weird and wonderful world of politics. Angelo, Fick, thank you indeed for your time on the show this morning. Assalamu alaikum to you.
Alaikum salam.
And of course, that brings us to 8:29, a very interesting discussion there with Angelo Fick, Director of Research at ASRI, talking about highlighting the Election Amendment Act, which was contested in court. Coming up in a minute or two is Tembisa Fakude, Senior Researcher at AfriCID, and we're going to be looking at an issue that's playing out in Libya right now. So please do stay with us.